Welcome back, viewers. This is part 7 of LiveLaw's election series, where we have been telling you about the important provisions under our election law. As we have already dealt with some important corrupt practices such as bribery, appealing to the voters in the name of religion, caste, etc., let us continue in this part with more such corrupt practices. Let me tell you in brief about clauses 4, 5 and 6 of section 123 of the Representation of People's Act 1951. Starting with clause 4, it talks about publication of false information by the candidate, his election agent or any other person with the candidate's or his agent's consent. The mode of publication can be anything. It can be a notice, a social media post or any advertisement. For example, calling a candidate a murderer or a corrupt politician. If it is a fact, no issue. But if it is false, then that would affect the reputation of personal character of that candidate, and the statement would affect the prospects of that candidate's election. This is very important in the light of various fake news and artificial intelligence based fake videos, etc. in the election campaign. What is relevant is the true statement of facts and not fake or false statements. Now coming to clause 5. Many of you may not even be aware that hiring or arranging a vehicle at the expense of the candidate, his election agent or any other person with their consent for carrying voters to the polling booth or polling station is a corrupt practice. We have been seeing instances where buses and trucks and cars are arranged by a political party or the candidate for taking the voters to the polling booth. By giving such facilities, you are creating an obligation for something in return to vote for you. This is also a corrupt practice because our election laws wanted free exercise of the electoral power of a voter and the right not to be influenced by any such factors. Because free and fair election is the basis of a meaningful constitutional democracy. Section 123, clause 6. This talks about another corrupt practice, that is incurring or authorizing expenditure contrary to section 77 of the RP Act. This section 77 that I mentioned talks about election expenses. There can be election expenses by the candidate and election expenses incurred by the political party leaders or the candidate's party. Both these expenses are separate. What is important is the election expenditure by the candidate. For every election, that is election to state legislative assembly or parliamentary constituency, Election Commission fixes the amount that a candidate can spend. And immediately after the election, the candidate should submit the election account with the Commission regarding the amount spent from the date of his nomination till declaration of the result. If the actual amount spent exceeds or is more than the account submitted, then it is a corrupt practice. In India, in reality, the actual expenditure for each constituency of major political parties is much more than what is actually spent. The real issue is how can it be proved in a court of law. These days, much amount is spent for indirect advertisement by paying to media houses and social media. The news appears just as any other news, but most of the content is actually paid. What is required is that the Election Commission must come out with more guidelines and modalities to access or to find out what was the actual expenditure by the candidate. Thank you for watching. You are welcome to share your views in the comment box. Stay tuned for more such crucial information regarding our election laws. Please do not forget to like, follow and share.